Good afternoon and welcome to Third Thursday with GBLA. My name is Cassie Mullican. I'm the Marketing and Communications Coordinator with Greater Bakersfield Legal Assistance. Thank you so much for joining us today. We're going to be doing a presentation on our Domestic Violence Reduction Project here at GBLA in recognition of Domestic Violence Awareness Month. Our guest presenter this month is Max Gradowitz. He is a staff attorney here at GBLA and he heads the Domestic Violence Reduction Project. So it looks like we have a couple people that are still kind of filtering through. We're going to go ahead and get started right now. Please do know a couple quick housekeeping rules. You have been automatically muted when you join the session, and then your cameras are turned off so we cannot see you. Towards the end of the presentation, we will have a time for question and answers. There's two ways with which you can ask your questions. You can either do raise your hand option, which you'll find in your text box on your screen. If you raise the hand there at the end, I'll be able to unmute you and you can ask live, or you can type directly into the chat or questions box. If you type those in at any point during the presentation, I'll keep a track of those and we'll ask those towards the end. So again, this is Third Thursday with GBLA. We're going to feature our Domestic Violence Reduction Project. And with that, I'm going to go to pass it over to Max, who's going to get started with our presentation today.
Thank you for the introduction, Cassie. As she stated, my name is Max Gradowitz. I'm an attorney here at Greater Bakersfield Legal Assistance. I oversee the Domestic Violence Reduction Project, otherwise known as the Domestic Violence Prevention Unit. And quite honestly, we usually just call ourselves the DV unit. We use the acronym DV a lot. And so if I use that acronym, that's what I'm referring to, DV, domestic violence. And here at GBLA, we offer quite a handful of different legal services. Assisting domestic violence victims is a big part of our practice. So I'm just going to talk to you about that today, a little bit about what constitutes domestic violence under the law, what can be done to protect yourself legally, what services we offer, and some things that we don't offer and don't assist with, so you guys have a good idea of if you're ever going to seek assistance with us, what we offer and what we don't, and just a quick run through of the procedures of going through a domestic violence case, so that you know what to expect if you are in an unfortunate situation where you do have to go through that. So you will have an idea how it works and an idea of the procedures if for whatever reason you don't qualify for our assistance. Most people will qualify for our assistance, but I'll go into that further. But at least you'll have a good idea of what to do in the somewhat unlikely event that we could not assist you for whatever reason. I mean, we're a law firm and we sometimes have conflict issues for various reasons, and funding limitations. So with that said, I'll go ahead and go forward with this presentation here. So just a little bit about domestic violence in general. There have been studies, statistics regarding domestic violence and its effects on children. Perpetrators of domestic violence are more likely to abuse children, not just their romantic partners. Perpetrators of domestic violence are more likely to pursue custody of children as well. And I don't think this should be shocking. This is probably a very large part of why we get a lot of our funding from sources that are meant to help children, is that children who witness domestic violence in the household are more likely to become both victims of domestic violence and perpetrators of domestic violence when they become adults. And that's likely because viewing, observing, hearing, etc., domestic violence in the household normalizes that. And so they're not only more likely to become perpetrators of domestic violence later in life, but also because of that normalization, they're more likely to get into romantic relationships with potentially abusive people and end up being more likely to become victims of domestic violence later in life. And According to a recent survey in California, approximately 40% of women polled said that they've experienced some form of physical, intimate partner violence sometime in their lifetimes. And of those that said that they had experienced such violence, 75% of them had children under the age of 18 years. Men are often the victims of domestic violence as well. And I see it in my practice. Honestly, the overwhelming majority of our clients are female. I think that's not shocking to anybody, but with every 30 or 40 cases I get at any given time, I always have 3 or 4 men. And although abuse from women on men in a romantic relationship happens less often statistically, men are certainly also victims of domestic violence. Less often, but definitely it definitely occurs. And men often feel more embarrassed or ashamed to report this for various reasons, social reasons, cultural reasons, or beliefs that police won't believe them, attorneys, judges won't believe that they are the victims of domestic violence. I have had several cases where my clients were really big, strong men, and I could tell that they were embarrassed when thinking, oh, we're going to go to court, and my ex-girlfriend is 5 feet tall and 100 pounds, but she's beat me, thrown things at me, caused substantial disturbance in the household, scared the children. So men are definitely less often, but definitely the victims of domestic violence as well. So what can legally be done if you're the victim of domestic violence, or if you know somebody that is experiencing this? What can you do, or what can be done legally? Obviously, there's ways to socially handle domestic violence, get out of the household, move out, whatever that might be. But from a legal standpoint, I think is that the focus of this presentation, and so that's what I'll go over right now. So if abuse has occurred and someone calls 911 and reports it, and law enforcement arrives and deals with it, however they're going to deal with it, the police have the authority to provide the victim, if they do believe that domestic violence has occurred, they can be given what I've acronymed as an EPO, and we refer to it often as just as an EPO, but it stands for an emergency protective order. It's at the discretion of law enforcement. So if you're the victim of domestic violence and law enforcement arrives, you can ask them. I imagine a lot of people don't even know this, that they can ask for this, but you can certainly ask a police officer for an emergency protective order. Ultimately, it's at the discretion of the police officers that are coming to the scene and the judge that they call. So what happens is, if they feel like they need to ask for an emergency protective order, the police officer or sheriff or whatever law enforcement officer will call a judge, and the court system has it set up to where there's judges on call 24/7 for this kind of stuff. They'll explain what happened, and the judge will give them basically the yes or no. And if that's a yes, the police officers will write it out, fill out a document, I believe it's only 1-page document, and it's a restraining order. It doesn't cover any custody stuff, because it's not meant to. It's meant to separate the parties, basically provide the victim with a short-term restraining order that basically says to the not the protected party, but the restrained party, that the restrained party has to leave. They can't come back. They can't be within, I think it's 500 yards or something like that from the residence. They basically have to leave, and they can't come back, and they can't contact the other person, the protected party. It is short term. They used to do them for only 7 days. I noticed that when COVID hit, they started doing them longer, 2, 3, 4 weeks. But it is a short time. It's meant to separate the parties for a short time. And it is only a restraining order. It doesn't address any sort of family, anything family court, the family law courts can, like making a permanent custody order or even a temporary custody order or anything like that. Another type of restraining order that can be issued is if, say the same scenario happens, that EPO expires, the police and the district attorney's office ends up bringing a criminal case against the abusive party. In that criminal case, that criminal court judge can issue what I've abbreviated as a CPO. That's a criminal protective order, and it's a restraining order, but it's the kind of restraining order that's given by a criminal court judge. So it's varying lengths. It could be how long the criminal case is pending. It's at the judge's discretion. It could be issued several years after, but there's no guarantee that that's going to happen. It's totally up to the judge. And again, it's only a restraining order, doesn't affect anything family law related. And finally, you can ask for a domestic violence restraining order in family law court. That is what we assist with here at GBLA. That is kind of what you do by yourself. It's not at the discretion of the police to give you, a criminal law judge to give you. You start the case yourself. You file the paperwork, you get a court date, you get the other party served with that paperwork, and you go to court, and have the judge hear your case. The judge will decide on whether to grant the restraining order or not, and it could be up to 5 years. The judge has the length of it is up to the judge. Sometimes they do it for 3 years, sometimes as little as 1, but they can go up to 5. And it could include specific family law orders, which is important if you have children, because that means you can, ask for like control of property, custody orders for children, financial stuff, that kind of thing. So who is eligible for our services? Obviously, you got to be the victim of domestic violence, and I'll go into what that is. Sometimes violence is obvious, but there's some not so obvious ones. But I'll go into the statute and what exactly that means. You have to be a resident of Kern County. Our services only encompass Kern County. You must be legally eligible for a domestic violence restraining order. So there has to be a domestic relation between the parties, and I'll go into that, what that means. And you have to meet our financial eligibility requirements. I apologize for that. Somebody got paged in our system. So you have to meet our eligibility requirements. Sometimes some of our funding sources don't have an income ceiling for the potential client. So we have a funding source for when the parties have children 5 or under, or if the female's pregnant. There's no income limit on that, meaning if you are like middle class, higher class income, we're not limited into not being able to assist you. Same thing for seniors, which is under our funding source, they define seniors as over 60 years old. There's no income limit for those. And then everyone else, we use our general funding source, which has an income limit, and it changes with inflation and stuff like that. But if you fall into that everyone else category and you do want to seek our assistance, just call and we'll let you know if you qualify. So what constitutes domestic violence legally? There is a family code that actually defines all this stuff. I'll go through it really quickly, and some of it's very obvious. Molesting, attacking, striking, stalking, threatening, sexually assaulting, battering, harassing, making annoying phone calls is described as in this other section of the penal code. Impersonating a victim, that's the way I see that in practice is usually hacking into your ex-boyfriend or ex-girlfriend or ex-wife, ex-husband, whatever, their social media account, and then just kind of using that as a form of harassment, acting like they're them and talking to their friends, maybe sending nude photos or whatever it might be. impersonating them, usually in an online social media sense, destroying personal property, and then one that's I like is disturbing the peace, because it's very broad. It just basically means causing a scene, yelling where the neighbors all come out, just causing, disturbing the peace. So in order to ask for this type of restraining order, you have to have a domestic relation to the other party. So that under the family code, that means current or former spouse or fiance, current or former boyfriend or girlfriend, or just parents of a minor child in common or multiple children in common. Even if there was no dating relationship, if you have children in common, forgive me the reference, but like a one-night stand kind of thing, if you have children in common, that would qualify as well. Any sort of cohabitant that's not just a roommate, so living together as an intimate partner or family. And then persons related by blood, adoption, or marriage. So parents, your children, grandparents, grandchildren. I unfortunately see quite often grandparents asking for restraining orders against their children or grandchildren, brother and sister, and then all of those things in law as well. So what can be ordered? No guns or ammunition is an automatic order if the domestic violence restraining order is granted. You can ask for a custody order and a visitation order, as I previously stated. The typical ones, though, are the no contact order and the stay away order. Basically, you can't contact the other person, you can't be around them anymore. And they will make exceptions for brief and peaceful contact for custody related stuff. So you can, pick up the child, talk to the child, obviously if you have visitation rights. You can add additional protected parties to the restraining order you ask for, but you have to have a good reason to, like they're also the victims of abuse. You can ask for a move out order. You basically have to live together to ask for that. Obviously, you can't just have someone kicked out of their own house when you don't live there. That's to get somebody out of the house so you can remain living there. And you can ask for control of property, pets, restitution for expenses caused by the violence, like broken windows, what have you. A batterer intervention program that the other party has to take, although that's very rarely granted in practice. And then other orders if there's something really specific you want to ask for. In terms of custody, if you have children with the other party, you can ask for a custody order. And if that's granted, there's no expiration date on those. So unlike the restraining order itself, it'll all be the same case, the same set of orders, but the restraining order will have an expiration date. The custody orders will not. So just keep that in mind. It's a permanent order. You have to go back to court to ask for something different if you want it changed. And then, a visitation order as well. You can ask for the other parent to have visitation time with their children. It could be supervised. There's a lot of different things that you can ask for in terms of custody and visitation. And how a restraining order affects that. Again, you ask for a custody order all in the same case with the same paperwork, and the judge will hear your case on the restraining order. And if the judge grants the restraining order, there's a family law code section 3044 that basically says if the judge finds domestic violence within the last 5 years, they're supposed to give the victim party the sole physical custody of the children, unless there's a really good reason to deviate from that presumption. Like if the other parent has completed parenting classes, anger management, they've gotten off of drugs, counseling, that kind of thing. Very rarely see it rebutted though in practice. You can ask for a move out order, like I previously stated. If the parties normally live together, meaning they either do live together or the abused party is temporarily staying at a friend's house, family member's house for just a few days to escape the violence, that's still fine. You still live there. It's just, you're temporarily staying somewhere else because you're being abused. So you have to normally live together to ask for this move out order. And if and you have to have some sort of legal right to reside in that residence, meaning you're on the title, you're on the lease, or you're not on the title and not on the lease, but you've been living in the property long enough to be a tenant, to establish tenancy rights. So you live there, not just staying for a few days at a friend's house. I mean, you live there. So don't think you have to be on the title or have to be on the lease to still have that legal right. You just have to have been living there for more than a week or two. So and if granted, the victim will give the orders to the sheriffs, and the sheriffs will go out and enforce the move out order at no cost. Enforcing the move out order meaning they will kick the other party out. They'll give them about 10 minutes to get their stuff and leave. So starting the process, you'll fill out the paperwork, file the paperwork. The judge will read your paperwork and decide whether to grant a temporary restraining order or not. The paperwork will be returned to you or your lawyer if we're assisting you. If we're able to assist you with that, then they'll return it to us. It'll have the court date on it, and then we just get the other party served before the court date and go to the court date. Serving the other party means you have to have somebody other than you give the paperwork to them. The sheriffs will do this for no cost, although they'll just attempt to. If the person never answers the door, it's not like 100% they're not going to kick down the door or anything, but they will attempt at no cost. You can also have a process server do it for a small fee, but it could be anybody over 18 that's not a party to the case, so basically not you or any additional protected party. And then whoever serves them just fills out a proof of service form, and you just make sure that's filed before the court date so that the judge sees that when they call your case, and they know that they have jurisdiction to hear your case. Without a proof of service, they cannot hear your case. It's not like they're just trying to be mean. It's the law. They have to have a proof of service showing the other party's been served in order to hear your case and make permanent orders. If you don't get the party served, just go to the court date, ask for an extension of time. The judge will give you another court date and extend any temporary restraining orders and eating custody orders that were previously in place will be extended to the next court date. So you'll still have a protective order and you'll get more time to serve them. And just note, these orders are not enforceable by police until the other party is served. So it's really important to get them served, because not only does it give the judge the right to hear your case and make permanent orders, it gives the law enforcement the ability to enforce them, meaning arrest the other party if they're violating them. So then you go to court, and assuming you have your proof of service filed, or you just have it on you if you don't have time to file it, just bring it to the court date. The judge can hear your case. If you have a lawyer, your lawyer will basically ask you questions and you need to testify about the abuse. And if you don't have a lawyer, the judge will basically just ask you those questions. If the other party shows up, they can say their side of the story. A lot of times they don't show up because they're not legally required to, but they can if they want to. And the judge will make a decision on whether to grant permanent restraining order or not. When I say permanent orders, I mean, this is what it's referred to in court is a permanent restraining order, but it's not literally permanent. It's just called a permanent restraining order because it's no longer a temporary restraining order. The temporary restraining order is what the judge gives you before your case is heard, so that you have a protective order that once you serve the other party with, at least you have a protective order in place while the case is pending. There's a lot of reasons why your court date could be reset. The other party shows up and asks for a continuance. Their lawyer shows up and say, oh, I was just retained on this case, I need more time to prepare. There's a lot of reasons why. So there's always going to be a temporary, assuming the judge grants it in the beginning, and they usually always do. You'll have that temporary in place until you get your day in court, and then the judge will decide on whether to grant permanent restraining order. But what's important is that it's not forever. They can go up to 5 years, and it's up to the judge. The judge will say 3 years, 2 years, 1 year, 5 years, whatever they want. But legally, they can only go up to 5 years. And then if there are custody and visitation orders, those are literally permanent. They don't have an expiration date. But of course, in the future, you can always go back to court, file paperwork to modify custody orders. But if you don't, they last indefinitely until the children turn 18. And say you get a 5-year restraining order and 4.5 years into it, you want to ask for it to be renewed, you can do that. There's separate paperwork to ask for a restraining order to be renewed. You have to file that and go through similar procedures as the original restraining order in terms of filing the paperwork, getting it back from the court with a court date on it, getting the other party served, and going to court again, this time to try to convince the judge to issue you a renewal. And the important thing is you need to file it before the expiration date, before your first one expires. If it expires, you can't file for a renewal anymore. So that, if you want to renew it, it's important you file it before the expiration date, at least like a month or two. And you have to have some basis to ask for the renewal. You can't just ask for it to be renewed for no reason. You got to have a reason. And the typical reasons are that, the person violated the restraining order while it was in the original restraining order while it was in place. And say they, came to your house, started banging on the door, you called the police, they get arrested, they go to jail for violating the restraining order. And then, a year later, you ask for the renewal. Well, that's your basis. They violated the restraining order. I still need a protective order in place. And then you'll go through those procedures, get a court date, get the other party served, and try to convince the judge to renew it. And I think I've already said this more than once, but if your custody and visitation orders are granted as part of your restraining order case, they don't expire with the restraining order. They don't have an expiration date. They can only be changed by either party filing a request to modify those custody orders. So what happens after court? If the judge grants your restraining order and you represent yourself, the court will prepare the paperwork and for those final orders, and they'll send it to you. If you have a lawyer, the court's going to send it to your lawyer. And of course, I'm sure your lawyer will send a copy to you, maybe keep one for their own file. That's usually what I do. I always send a copy to my client, obviously, because it's good for them to have if they ever have to, unfortunately, if they ever have to show it to police in the future because of some incident of the other party violating it, they have it. Yeah, and it is important if you represent yourself that you pay attention on whether the court will require you to serve the other party with the final orders. This usually happens when the other party doesn't show up to the court date. So you serve them at first, you get your day in court, they don't go, the judge grants the restraining order. If the orders are the exact same as the temporary order and it's just now made a permanent order, if the other party doesn't show up, the court is going to check a box on that paperwork that says you have to serve, you can serve the other party by mail at the last known address that what you previously served them at. If the orders are different than the temporary restraining orders, like the judge makes a modification or something and the other party doesn't show up to the court date, you need to personally serve them with those final permanent restraining orders. Again, service is really important in these cases because if you don't serve them with the final orders, it's not enforceable by police. When you serve them, the proof of service that you file with the court forwards it to CLETS, which is a computer system database for police officers and law enforcement officers that show that a restraining order is in place. And if it's not in their system, a lot of times even if you show them the paper, they won't enforce it. So service is really important. Pay attention to that. If you have a lawyer representing you, they'll know to do that step. But I just want to clarify that part because it's important. Because you normally would think you're done with everything, but oftentimes if the other party doesn't show up, there's some sort of service requirement to kind of finalize everything and make sure that final permanent restraining order is in effect and enforceable by law enforcement. So how can we at GBLA help? Well, basically you could schedule an appointment with us. We also get a lot of referrals from other entities that refer people to us that are victims of domestic violence, but however you get to us, the first person you'll talk to will assess your eligibility and make sure that you are, in fact, I mean, this is a domestic violence situation, not just like a divorce or purely a custody issue that you have. So they'll assess your eligibility and your situation, and if you qualify, we can assist you and in many cases represent you in a domestic violence case. And this includes asking for a custody order as part of that restraining order, assuming you have children with the other party and you want to ask for custody orders. And note that our assistance and our representation is always subject to funding and resource availability. Sometimes we have several attorneys on staff, sometimes we have one in this unit anyway. And then, you know, our funding is, we've always consistently had funding, but you never know. So all of our services are subject to funding and resource availability. So don't, there's no guarantees, but historically we've always been pretty solid. So, but I just want to kind of give that caveat. And if necessary, if you don't qualify for our services or for whatever reason, we are always available to refer you to other entities that can help you with other things you might need, like public benefits, shelters, things like that, whether we assist you with the restraining order or not. We always have a lot of references to shelters and public benefits and other things you may need being a victim of domestic violence. And what we cannot assist with because of our funding limitations, our funding sources restrict us from assisting with non-emergency, non-DV family law matters. So this is, you know, divorces, separations, custody cases, just pure custody cases with no significant violence, you know, domestic violence involved, child and spousal support, and, you know, non-domestic violence restraining orders, like you want to ask for a restraining order against your neighbor. Well, that's not a domestic situation. There's a different type of restraining order for that, and you can pursue that in a different court, in the non-family law court. But for our funding and stuff, we couldn't assist you with that, unfortunately. But if after assessing your situation, it's our opinion that the best option is, you know, maybe asking just for a custody order for you, or divorce, or, you know, whatever, we can always refer you to the appropriate entity that can provide you with the paperwork that you need to ask for that. Like the family law facilitator, they're part of the court, and they help people fill out the paperwork for stuff they need, whatever that might be. And other resources that are beyond us, or, you know, not us. National Domestic Violence Hotline, if you Google that, it's a national hotline for domestic violence victims, and they will refer you to anything local that you may need, shelters, public benefits, legal aids like us, you know, that kind of stuff. Locally, there's the Family Justice Center and the Open Door Network. They're more of a bigger picture entity for domestic violence victims. They can directly refer you to shelters and public benefits, things like that. To, you know, they're not law firms like we are, but they are more of a holistic approach, and they refer a lot of people to us. In fact, that's where we get most of our clients are from them. And then, of course, the district attorney's office is the entity in locally that provides information to the prosecutors and the deputy DAs to bring criminal charges. So if you feel like you are the victim and you want to press charges criminally, you'd contact the district attorney's office in whatever county you're in this case, Kern County. And that is the end of my presentation. So I guess I will send it back to Cassie. And any questions, I'd be glad to answer them to the best of my ability. But it was a pleasure speaking with you guys, even though I can't see you. It's always a pleasure to put these presentations on, and I'm sure Cassie will give you some sort of information. If you can't think of any questions now, we're always available to contact for any questions you might have regarding this kind of stuff. All right.
Yes, thank you so much, Max. That was really great information. So at this time, if you have a question, please use the either raise your hand feature or type into the questions or the chat box. I'll give it just a moment. And in the meantime, all information about our services can always be found on our website at www.gbla.org. The best way to reach us and apply for assistance is 661-325-5943. That's our main intake line. Can always reach out. And then, of course, when you registered, you were given my email address as a contact. So if you don't happen to have any questions right now and you have some in the future, feel free to shoot those over to me via email, and I can get those over to our DV unit and get those answered. So I'm going to do a final check here, make sure we don't have any individual hands raised or questions in the chat box. And I don't see any. So with that, we're going to go ahead and end. Thank you again so much for joining us for Third Thursday with GBLA. I will keep posted on informational videos. Obviously, Third Thursday in November happens to be on Thanksgiving, and we won't be present. So we may change the date for that temporarily. But as always, we'll post to our social media channels on our website. And of course, if you're not on our distribution list, make sure you email me at kmolican@gbla.org to add on to receive those invitations. And with that, we're going to go ahead and close out. Thank you so much for joining us. We hope to see you next month.